We're here in cause number 19-32623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are.
From the very beginning, observe how the judge deliberately places the discussion on the record, a move that carries significant legal weight. In courtroom procedure, anything stated on the record becomes an official part of the case history, shaping potential appeals, influencing sentencing decisions, and guiding future hearings. This is why critical matters are never left to informal hallway conversations. In law, if it is not on the record, it effectively does not exist in the eyes of the court.
First of all, sir, you're Dalvius Williams, and Mr. Williams is here with Mr. Rojas. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to.
This is a turning point in the proceedings. The judge rejects the plea agreement due to a new allegation, and in real courtroom strategy, fresh charges or violations can immediately shift the entire negotiation landscape. A deal that seemed secure one day can vanish the next, replaced by greater uncertainty and higher stakes. In that seat, the decision becomes intensely strategic: risk the unpredictability of a trial, or accept the certainty of a shorter sentence while the opportunity still exists.
Pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct?
That's correct.
So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. And so, Mr. Rojas, what is y'all's position?
Judge, I think after discussions with Mr. Williams, I think he would like to withdraw his plea of true to count number 3.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count?
Yes, ma'am.
Okay. And then count 2 alleges that you're behind in your court-assessed fees as of January 4th of 2023 in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count 2? Count 3, which was in the added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th of 2024. You had previously pled true to that count, and do you want to change your plea of true?
Listen closely to what just unfolded. Shifting a plea from true to not true may sound like a small change in wording, but in legal terms it is monumental. That single decision strips away any admission and places the full burden back on the prosecution, requiring them to present witnesses, evidence, and proof instead of relying on a straightforward acknowledgement. In an instant, what could have been a routine formality transforms into a fully contested hearing where every claim must be tested on the record.
Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses, Judge. Okay. They're going to serve a warrant at his house. There were 2 officers in the back that see him come out of the back of the house.
Okay.
Knocking on the front door, so we need both of them.
Okay. Okay. All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony, correct? No. That's
Yes,
been, oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a third-degree felony. But that possession of a controlled substance is a third degree as well. So the range of punishment.
Now the judge lays out the punishment range, 2 to 10 years. And this is the moment when reality truly settles in. Sentencing ranges are not just abstract numbers. They define the stakes of every choice that follows. Each plea, each rejection, and every calculated risk is weighed against that window of possible time behind bars, turning legal strategy into a deeply personal cost-benefit decision about freedom, uncertainty, and consequence.
Mr. Williams, I also want to make sure you understand that if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojas, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go through everything, what his options were, and all of that this morning. Is that correct as well?
That's correct,
Okay. What if any offers? I want to make sure Mr. Williams, on the record, rejects anything that's been offered.
We had offered 4 years in this case, Judge, and he is rejecting that offer.
Did that include an offer in the injury to a child?
Actually, I offered 4 years in both cases to run concurrently.
Okay.
If he went today.
Okay.
He said no. And I told him that if he didn't do that, if we go to trial on the new one, I would move to stack that case on whatever he gets in this case, and the 4 is off the table on this case.
Okay.
Here is a term you will hear frequently in court: stacked sentences. This means the sentences are served one after another rather than at the same time. The difference is enormous, turning what might have been a 4-year term into 8, 10, or even more. When prosecutors raise the possibility of stacking, it is rarely casual. It is a strategic signal of leverage, quietly reminding the defendant how much greater the risk becomes if negotiations fail.
I apologize, and I didn't hear what the last part. Did Mr. Smith talk about the 4-year offer for today to the possession of a controlled substance, and if he were to be tried in the future, if he were to be convicted for the injury to a child, that case would be stacked? Did you say that?
He would request it, and it's up to me. So anytime the state asks for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today, we have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with a plea in both of your cases, plea of true in that motion to revoke for a 4-year sentence, plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if we go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do?
True to first, but not to the injury to the child.
Okay, then we'll go forward with this hearing. So I want to make sure also for the record what all I've reviewed. The original PSI, obviously from being placed on probation is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, I just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. It starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me?
Yes, ma'am.
So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches. 2016, burglary of a vehicle, 30 days jail, and then 2019, a resisting arrest again and an evading arrest also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020. Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon, also same disposition date of January 10th of 2020 for the 12 months in the state jail. And then there was this possession case that we're here from that same date. So it looks like he